the Albanian government has approved the agreement signed by Prime Minister Edi Rama and his Italian counterpart Giorgia Meloni relating to the processing of asylum claims by Italy on Albanian territory, with the next step being a vote in Parliament. The Memorandum of Understanding will see 2 centres set up in northern Albania, which will deal with the evaluation and processing of asylum seekers and refugees rescued from the Mediterranean by Italian vessels. The structures would be built, funded and operated by Italy under Italian jurisdiction, wholly closed, guarded by Italian authorities and also by Albanian police outside. The centres could hold up to 3,000 people at any one time, with a maximum of 36,000 over the course of a year. When a decision has been made on the individual's application, Italy retains full responsibility for removing them from the country, either to Italy or another location. Now, for the draft law to pass and the agreement to be ratified, a minimum of 71 votes out of the total of 140 is required, a threshold that should not be hard to meet, as 74 would come from Rama's ruling Socialist Party, which can also rely on backing from its other allies. This means that unless there is a significant rebellion among the socialists or their allies, the law will pass, although, knowing Albanian parliament, considerable debate is expected. But criticism of the deal from human rights organisations, and this week the Council of Europe's Commissioner for Human Rights, Dunja Mijatovic, continue to flood in, casting uncertainty on its future. I'm joined online today by Flaminia Delle Chiesa, the Senior Legal and Advocacy Officer at the International Rescue Committee in Italy. Good afternoon, Flaminia. Thank you for joining us on Inside Albania.
Good afternoon. Thank you for having me.
Now, regarding the deal, the dust has settled somewhat. It's been 2 weeks since it was signed, and there's been a bit more information about it since then. Plus, lots of assurances from politicians that absolutely everything will be fine. Do we still have the same concerns that we did when we first found out about this deal? And if so, what are the key legal concerns and uncertainties?
Our concerns indeed do remain the same as a week ago, as there are both procedural and substantive resolved issues that still need to be addressed. From a procedural point of view, meaning from the rules and the proceedings that have to be followed for the deal to be implemented, the main problem now lies with the ratification of the deal by the Parliament, which means a vote of approval of the deal through the adoption of a dedicated law. So Article 80 of the Italian Constitution requires that some international treaties that are political in nature or provide arbitration or judicial regulations or import changes in territory or burdens on finance or amendments to law need to be submitted to the Parliament for the ratification, so that the content of such deals can be actually subject to due scrutiny by the Parliament, by the members of the Parliament. Indeed, the Italy-Albania deal seems to meet all of the requirements, so a ratification should be needed. However, the deal was signed without previously informing the Parliament, and the position of the government now is that no ratification is needed because this deal originates from previous treaties and deals within Italy and Albania. In particular, a treaty that dates back to 1995 and another agreement that dates back to 2017. The problem is that the position of the government cannot be upheld from a legal point of view, because in particular, the 1995 agreement was mainly aimed at regulated migration from Albania to Italy, which is, of course, a totally different issue than offshoring detention from Italy to Albania. So this explanation does not mean that the ratification obligation need to be circumvented.
So I just want to check what you said a second. So, sorry, just 1 second, just to clarify one point. So what you're saying, so in Albania, they are going to ratify it. It's going to be voted on in Parliament. So, but in Italy, this is not going to happen?
The position of the government is now that the ratification is not needed. Wow. It has been clarified by relevant government spokespeople, precisely because they say that it originates and the basis for this agreement is lying on previous agreements that already set the ground for this agreement to be implemented.
So it's not going to, potentially not going to go through that process at all. And how are other politicians from other political parties sort of reacting to this?
The opposition parties have actually sent a letter to the president of the Chamber of Deputies asking for the ratification to take place because they want, of course, to have their say, to have to go through the normal procedure. So it would entail the adoption of a law that needs to harmonize the protocol with existing national, EU, and international law. So they're very much pushing for this. And actually, the Ministry of Foreign Affairs is speaking to the Chamber of Deputies next Tuesday on this deal. So we're not sure whether on that occasion this issue will be clarified even further.
Now, as for the deal itself, let's say it all goes through as is. Do you think it's possible to implement such an agreement in a way that is legal and ethical? So is there a legal and ethical pathway to processing the asylum applications of individuals in Albania under Italian jurisdiction?
At the moment, of course, as we just said, the very problem is the procedural aspect, so the ratification. Even if this procedural obstacle is overcome, the actual implementation of the deal would still face significant practical and legal barriers. And the list of such a barrier is long, but I can mention a couple of examples. So firstly, Italian authorities in Albania would have to ensure that asylum seekers in Albania enjoy the same rights as asylum seekers in Italy. And these include the right to a fair hearing, including the right to access and be represented by a lawyer. The text of the agreement actually says that different actors, including lawyers, will be granted access to the centers in Albania, but this may prove inadequate for lawyers to actually represent all the people that will be at the same time in these centers. And this holds particularly true for one crucial moment that needs to be happening within 48 hours of the detention, which is the judicial review of the detention. So the moment in which a judge has to confirm whether or not the detention order is lawful. Secondly, there is another consideration to be done on the conditions of people in these centers, because those conditions may be in breach of Italian law, EU law, international standards, and it is not yet clear whether Italian authorities, and in particular the ombudsman for the people of deprived of their liberty, will be actually able to implement their monitoring mandate in those centers. And less than 1 month ago, the European Court of Human Rights actually found Italy guilty of subjecting 3 Tunisian migrants to inhumane and degrading treatment in the Lampedusa hotspot in 2017 and 2019. So if the conditions were not considered adequate and in alignment with international standards in Italy, it is very likely that the same may happen in centers in Albania.
Now, on to recent news from this week. The Supreme Court in the UK has ruled that the plan to send those seeking asylum in the UK to Rwanda to process their applications there, but also to leave them there, if they are accepted, that has been ruled as illegal. Now, I know there are differences between the two proposals. For example, in the Albanian case, whether someone is granted asylum or not, they still ultimately leave Albania, which is not the case with the UK. But do you think this decision and the fallout from it politically and socially and legally could have any impact on the future of the deal between Albania and Italy?
The judgment issued by the Supreme Court in the UK was indeed landmark and must serve actually as a wake-up call to governments to abandon their pursuit of ineffective deterrent measures and instead deliver a more pragmatic, humane, and ultimately lawful asylum system. And the Supreme Court in the UK found that the UK policy is unlawful and that there are substantial grounds for believing that the removal of claimants to Rwanda would expose them to a real risk of ill treatment by reason of refoulement, in breach of Article 3 of the European Convention on Human Rights. As you said, the case of the Italy-Albania deal is slightly different, especially because in this case, the asylum procedure, the return procedure, will be implemented by Italian authorities abroad under Italian jurisdiction, so not by third actors or third countries. But still, the UK judgment is clear in stressing that what matters in the end is that asylum seekers in another country can enjoy rights and guarantees and access a fair asylum procedure as asylum seekers do in the country itself. So in both the UK and the Italian case, the governments must fundamentally rethink their approach and deliver a fair and effective system of protection for everyone.
My last question. Do you think Italy and Albania were expecting such a negative response from this deal? I mean, it's been across the board. The European Commission has been a bit diplomatic, but it's quite clear they're quite concerned about it. Human rights organizations, the Council of Europe, legal and migration experts, political parties from different sides, members of the public. It's been quite a full-on response. Do you think they were expecting it? Do you think it can damage them politically? Do you think this deal is ever going to really be implemented?
So the deal was not previously communicated from the information that we know to relevant institutions. So it was to be foreseen that when the news would be made public, then they would express their position and react in a way. In addition to the UK round example that we just mentioned, this is not the first time that a EU member state tries to look into the possibility of striking an offshore migration deal, but there are, in the end, fundamental reasons why these past proposals have not gone ahead, and this might apply to this case as well, because eventually the process of offshoring is beset with several flaws on moral, legal, practical grounds, and fundamentally outsourcing responsibility to assess asylum claims cannot be consistent with the member states' human rights obligation. And in terms of the reaction from international human rights bodies, human rights organizations, experts, they have stressed their concerns in those past occasions, and therefore it's not surprising that they're stressing them again in this case, especially because this deal might set a precedent for other EU member states contributing to a troubling trend. And finally, with respect to the reaction of the public, people in Europe do have a huge capacity for welcome, as we have seen in the recent years with the response and the efforts of communities, especially to support the Ukrainian refugees. Therefore, these kinds of efforts to prevent people arriving to Europe are not necessarily in line with public sentiment.
Flaminia, thank you very, very much for your time and for these explanations.
Thank you very much.
Thanks.